proposed changes to our constitution, which focuses on the definition of family, care in the home and references to women and mothers. This morning we'll hear both sides of the argument, starting with why people should vote no to both referendums. Joining me is Laoise de Brún BL of The Countess, and The Countess is a grassroots campaigning organisation for advocates of women, children and LGBT young people. Good morning to you, Laoise.
Good morning, Patricia. How are you?
Yeah, I'm very well, and you're very welcome. Thank you for joining us. Okay, let us start with the referendum on the family. Why do you want people to vote no and leave the constitution as it is, which gives status only to a family based on marriage?
Well, I would say that no one in Ireland is precluded from marrying. If you are in a same-sex relationship, you can marry. Luckily. So if you want to formalise your affairs with regard to tax and succession and inheritance, then there is a mechanism there available to everyone, which is called marriage. This has nothing to do with religion. It's to do with a public contract between two people based on consent, whereby there's certainty to the beginning of it, the end of it, and actually you can't just walk away from it. You have to go to court. A court order has to be made, and provision has to be made for the dependents of that marriage, if there are any, including the woman, if she, let's say, has given up her work. So what that means is that marriage is there for a reason. It provides certainty and protection for people. It is not the case. There's lots of misinformation, Patricia, with regards to, apparently people are not treated as equal under the Constitution if they're not married, or children are not treated as equal. This is completely untrue. And in fact, a very recent case that came before the Supreme Court, the O'Mara case, which you may have heard of, proves this. Because in the O'Mara case, this was a widower who initially was told that he couldn't claim his ex-partner's widower's contributory pension because they hadn't married ever, even though they had 3 children together and were together for decades, and sadly she died. However, this went before the Supreme Court, and the Supreme Court found that he had to be treated as if he had married, and the children had to be treated as if they were the children of a married couple under Article 40. So Article 40 already protected them. So what that means is the Constitution already provides equality for children and for couples who are unmarried. It's simply not the case that they are not treated as equal under the Constitution.
Okay,
Secondly, we are
outside of couples who are in a relationship and who deem themselves families. You say they have every right if they want to get married or not. What about other families, a family that's headed up by a single parent?
Yes, well, this was actually, you're quite right. This is what I was about to come to. So what we are doing is we're bringing in a new term which is completely alien to Irish law, called durable relationship. And this is actually, Patricia, it comes from European law, and it's to do with freedom of movement of workers within member states. So it's if the case of someone is from a member state and they want to move in order to work to another member state, and then they can be joined by their boyfriend or girlfriend. These are relationships between 2 adults based on consent. So therefore, you could argue single parents, and let's be honest here, most of them are single mums who have in the past been incarcerated by this state and do feel, quite rightly, they have been stigmatised in recent years. They are not even being protected. They're not being brought under any kind of cloak of protection by this new wording. Durable relationships do not pertain and cannot pertain to them because they're based on 2 people based on consent. So it's not doing anything for single parents whatsoever, and it's also debasing and diluting what we know to be marriage, which will cause utter chaos with regard to tax, inheritance, succession and immigration. It is really bad law to bring in a term that isn't defined, and it is simply not the case that the courts will sit down one afternoon and decide what this means. It'll be decided on hard cases when people are in dispute. And actually, after all, since 2010, we have legislation in this country where cohabitants who are together for 5 years, no less than 5 years, and they must be living together consistently in an intimate relationship, they actually have rights to property. And Patricia, if you are a cohabitant and you have a child together, after only 2 years you have rights. So to me that seems kind of sensible and common sense. So there are rights already there for people who live together, but this is really throwing the gate wide open to we don't know what actually. We're kind of heading blind over the edge of a cliff, and it is absolutely no way to treat our constitution, which after all is our foundational legal text and highest source of law.
But it is estimated that about 1 million people are not part of a married family. Not everybody agrees for whatever reason or wants to actually get married. So if there's 1 million, that's a fifth of the population. And I saw our former president, Mary McAleese, saying that a yes vote would give respect and recognition to families not based on marriage. She says they're deliberately absent from the constitution at the moment.
Well, I hope I've made a clear case there for the difference between marriage and a more casual relationship is because it is it's formalised. You have to go to court to end it. Provision has to be made for dependents, therefore they are protected. The whole reason that marriage is mentioned the way it is in the Constitution is because it isn't the same as just being in a relationship and that, there is a difference. They are contrasted. Obviously, if you want that state recognition, then you can simply get married. It has nothing to do with religion. You can be 2 lesbians or 2 gay men and still get married. And in fact, that campaign that was fought at a grassroots level for gay marriage, I'd like to hear, maybe from that community. I mean, what was it all for if now, a more casual relationship can be the same thing as marriage? So it is simply not the case that people who are unmarried are in any way discriminated against. And I don't know what this means by respect when, as I have said, people who cohabit actually do have protection under the law, under positive law. And as I said as well, under the Amara case, this proves this is the most recent case. It went all the way to the Supreme Court. And what they found was that, and actually what happened in Amara, initially cancelled for Amara, the barrister for that widower was only fighting his case on the basis that he believed that only children would be treated as equal under the Constitution, that Omar, the man himself, the widower, would not be. And it was the Supreme Court's justices themselves who said to him, go back, we'll adjourn the case, you need to redo your submissions and broaden it out, because under Article 40 of our Constitution, as it now stands currently, actually the widower himself, Omara, was protected and had to be treated as an equal. So in terms of his case, the comparator, or the abstract person that he was compared to, was a man who actually had married. So under Article 40, he had to be treated as equal. It is not the case that the people who don't marry are not given respect under constitutional law in this country. It is simply not the case that they are discriminated in any way when it comes to positive law. By positive law, I mean statute and statutory provision, laws enacted by the Oireachtas.
Okay, let's move on to the care referendum, and this is the one that if it was a yes vote went through, it would remove the word woman. It would recognise, if it was taken out, it would, at the moment it recognises the common good of life of woman in the home, and that she should not have to go out to work to the neglect of her duties in the home. We should endeavour to ensure that she can remain at home if she wants to. Why do you believe that should remain in place?
I believe that it is a protection for mothers and for children. I think it was actually ahead of its time. Now, I do concede the language is sort of paternalistic in tone, but I don't think it's misogynistic. I think it's actually a beautiful recognition of what mothers do. When you ask mothers what they actually want, you will find in the latest survey, which was a survey done by Amorach, 69% of mothers of young children would rather stay at home with them. When you ask children, the Journal did a survey. They asked children how many would you like to stay at home with your primary caregiver, is how they worded it. This is, as we know, 95% of the time this will be the mother. Only 1% said they'd rather go to creche or daycare.
Yeah, but a cost of living crisis, Laoise, dictates that women have to go out and work.
Oh, precisely. So obviously the way we have ordered our economy and the way this country runs, and with the mortgages, and people are trapped in commuter hell, barely seeing their children, as they too have pointed out. But when you read the Article 41.2, what it's saying is that it's a bulwark against that. Now, yes, arguably it wasn't fully realised, and the state have never done that. And that might well be, Patricia, because the courts traditionally are very reluctant to get involved in sort of on a policy level to get involved with sort of the public purse. What the Oireachtas should spend its money on. However, I will say that it has been used to protect women and children in the following way. So, for instance, in this country, we set it's court policy to protect the mother who's decided to stay at home, let's say for the duration of a marriage, after that marriage breaks up. So what I mean by that is, after there's a divorce and the marriage is dissolved, in this country, unlike other countries, if that woman has given up her career and stayed at home to mind children, she won't be forced out to work. If the man has means, he will have to continue that arrangement and provide for that arrangement that was there. So that is explicitly because of 41.2. So it's there as a legal safeguard, a legal protection for women and children. Secondly, I would say that this idea that, mothering is the same as caring is just a nonsense. I don't believe it's progressive to pretend that mothering is simply caring. It is not the same thing. Mothering is something that is biological. We all have to surely agree that mothers should be supported and empowered by society, because if we can, on an individual level, if a child has a secure attachment with their mother, that gives them protection for life. But as a society, obviously it's better for society to support mothers in this way.
Okay.
And I don't think it's the case that leaving your child that you don't want to leave in daycare and going out to work is liberation or is equality.
Okay, but do you agree that women's groups, Laoise, have campaigned for years to remove Articles 41.2.1 and 41.22, saying they're out of date, they're written for a very different Ireland, and even back when it was put into the Constitution back in the 30s, there was women's groups who were against it at the time.
Well, I'll answer those things in turn. Firstly, yes, I think it's true there has been a campaign to change the language. I wouldn't agree that it is where we've got to in terms of the language. I think the language is the wording that we've been asked to vote on is a dog's dinner. It gives nothing to anyone. It doesn't give any provision of care to actual carers or for the cared for. In fact, it's a watering down of rights and of obligation placed in the state. We are outliers in Europe. We're the only country in Europe whereby people who live with disability don't have a statutory right to live independently. We have refused to ratify the UN Convention on Equality for People with Disability. We need to judge this government by its actions, not by its words. This, I believe, is a smokescreen that's been created based on kind of slogans, a bit like Brexit, but no one is working out what they're actually doing in reality to the legal framework. What I mean by that is, on a daily basis, Patricia, primary school places are found for children. And do you know why they are? Because the Constitution says the state shall provide. Now, currently in the Constitution, what we have, and the wording that is there, is the state shall endeavour to ensure, and it's that protection for women. Now, yes, arguably it hasn't fully ever been realised, but as I have outlined, there is protection there that has been found by the courts for women and children. But what they want us to vote for is the state shall strive. The state shall strive. Shall strive doesn't mean anything, and they know this.
Okay, but yes, carers, Laoise, carers are going to get mentioned, and I know Family Carers Ireland say the referendum is a landmark opportunity for carers. That people want care to be contained, the word care for carers to be recognised. And I saw Roderick O'Gorman this morning saying passing the referendum will strengthen the hand of ministers at budget time to support carers.
Yes, this is obviously the narrative that we're hearing all the time about. I've also heard the words platform to advocate for greater care. None of this means anything. It doesn't mean anything. It is naive to assume that somehow by changing the wording that they have a stronger hand. They could enact legislation tomorrow, Patricia. As I've said to you, they haven't ratified the UN Convention on Equality for Persons, presumably because they don't want to be beholden to spend that money that it would take to provide proper provision of care. And in fact, I would say that it isn't the case that all civic society groups with regard to care are in agreement. I mean, there's one group that came out and said that it provides absolutely nothing for carers, so they've obviously done the critical thinking around this and realised that it doesn't actually give anything to carers.
But in fairness, the majority of care groups and again, carers, people representing carers are in favour. Leisha, I have to leave
it
there.
I can assume that's because Roger Gorman said we expect you all to come out for a yes.
Okay, listen, I leave it there, but you're saying no, Leisha, and listen, you've certainly laid out the stall, so we thank you for that, and thanks for joining us this morning.
Thank you so much.
Good morning to you. That is Laoise de Brún BL of the Countess.